presented. And we also have counsel representing an interested party in joining this proceedings. And we'll proceed with that matter first. That is the matter relating to the subpoena of records or documents in possession of Mr. Rand. Parties ready to proceed?
Yes. Good morning, Your Honor. Anthony Glassman, appearing on behalf of Mr. Rand.
All right. The court did receive a brief filed by the prosecution and Mr. Rand. Also a declaration or affidavit filed by Mr. Rand. And the prosecution initially indicated in its papers that it felt that the people wanted to or should have an opportunity to cross-examine Mr. Rand. Is it still that desire?
Yes, Your Honor.
Mr. Rand here?
Your Honor, Mr. Rand is here. Might I inquire, would Your Honor like me first, just so we have one record of Mr. Rand's background, his experience, and the history surrounding these tapes, to put him on and take him through a brief direct examination so the record is all complete, and then allow the district attorney to cross-examine?
Well, would there be anything offered in that examination that is not already contained in his affidavit?
Well, I think we pretty well sketched it in, Your Honor.
Is there any objection by the prosecution to the court receiving that affidavit subject to right of cross-examination?
No.
And Mr. Glassman, if there was anything else that you wanted to add that you feel was left out in that particular declaration or affidavit, I'll certainly give you a chance for cross-examination to bring that out.
All right, I'll reserve that for cross-examination.
Okay.
As indicated in Mr. Rand's declaration, we have brought for Your Honor's in-camera review. It actually doesn't have to be on camera because these are the transcripts of the previously aired and published sound bites. We have those if Your Honor wants to look at them, both for Eric Menendez and for Donovan Goodreau.
Well, that is one issue that perhaps we can discuss during testimony, permit me to get more information about it. You didn't bring the actual so-called sound bites, but just transcripts?
We have transcripts of the sound bites that were made by Mr. Rand.
Well, clearly the people in their subpoena were asking for the tapes themselves, so at the very least they would be interested in the tape recording that was the source of that soundbite rather than, or that transcript rather than, instead of the transcript.
You mean the portion of it that was aired, Your Honor,
Yes.
so they can listen to it?
Yes, or use it for whatever purpose they want.
Mr. Rand can play those, Your Honor, if that's necessary. That previously aired portion does that.
All right, then let's have Mr. Rand step forward and we'll proceed with the examination. Just jump. And Mr. Weiss, if you want to sit down somewhere, it's, or if you want to sit in the jury box, that's fine.
Please raise your right hand. Do you solemnly swear that the testimony you may give and advise nothing before this court will be the whole truth and nothing but the truth so help you God?
I do.
You may be seated. Please state your name for the record.
Robert Rand, R-A-N-D.
Your Honor, before we commence the examination, Mr. Rand, for the record, Mr. Garrett has asked me for a copy of the previously published soundbite transcript and making that available to her. Well, rather, I'd like to mark one as Exhibit A or Exhibit 1 to this proceeding here at Your Honor's clerk.
Okay. Well, thank you. We'll make it Exhibit 1. This is of both tape recordings?
Yes.
Okay.
The first page relates, Your Honor, to the soundbite of Donovan Goodreau, and the second are the aired portions of the soundbites in connection with the Eric Menendez.
Okay. Thank you. And who's going to conduct the examination?
I will.
All right, thank you. Let's proceed. Perhaps in addition to whatever you intended to go into, and perhaps this is part of it, can we have some delineation for the record as far as the Goodreau tape recording, when this tape recording at issue in this hearing was made in relationship to the other tape recording that was the subject of a hearing that occurred during the trial and an order of the court that caused that tape recording to be produced? And because I don't see that clearly, maybe I'm missing it, I don't see the dates specified. I want to learn that as well.
Right, just to give Your Honor a frame of reference, the previously produced tapes pursuant to court order, I believe, were made on March 26th and March 27th of 1992. The 10-minute tape, which is an issue, the only tape that Mr. Rand has that has not previously been produced, was made on December 7th of 1990. That's a 10-minute tape, and approximately 10 seconds, and only 10 seconds, have previously been aired. And also at issue, and the only other tape responsive to the people's subpoena would be a tape made on October 22nd, 1989, and that's a 2.5-hour tape, which was an interview with Eric Menendez.
Yeah.
There are no Lyle Menendez tapes.
Okay, I see that in the declaration. All right, again, you may proceed.
Thank you. Mr. Rand, you recently published an excerpt from an interview that you conducted at some time in the past with Donovan Goodreau.
Yes.
And when was it that you recently published that excerpt?
There was an excerpt broadcast May 24th, 1994 on KCBS TV, the 11 o'clock news. And there was also basically the same soundbite was broadcast on a syndicated program titled The Conspiracy Tapes from Tribune Broadcasting that was aired in Los Angeles June 2nd, 1994.
Now, the original recording from which that excerpt was taken, when was that recording made?
The interview was recorded December 7th, 1990.
Do you have that original recording with you today?
Yes, I do.
How long is that original recording?
The original recording is 10 minutes long, approximately.
Was that recording made over the telephone or in person?
The recording was made over the telephone.
Was the person being recorded aware of the fact that he was being recorded?
Yes.
Was that Mr. Goodreau?
Yes.
Was that the only recording that
I also made a recording of Mr. Goodreau in March of 1992 over a 2-day period, and the recording of that interview was turned over to this court during trial last July, a year ago.
Now, was it your intention when you turned over that recording to turn over all recordings?
Yes.
At that time, were you aware that you had an additional 10 minutes recording that you did not have?
No, I was not aware at that time.
Were you aware of the fact when you turned over that recording to this court last year that the subject matter on which the parties in this case was focusing was the statement by Mr. Goodreau concerning a statement made to him earlier by Lyle Menendez concerning being abused by his father?
Yes.
And the excerpt that you have just recently published is an excerpt in which Donovan Goodreau speaks about Lyle Menendez making a statement to him about being molested by his father.
Yes.
And it was your recollection last year when you turned over the recordings to the court that Donovan Goodreau had made no similar statements to you in the past prior to statements that he made to you in connection with this subject matter in March of '92?
Donovan Goodreau had made many similar statements. We probably had perhaps 24 interviews since I first met him in July of 1990. And on many occasions, he made similar statements. However, I wasn't aware at the time that I had another tape-recorded statement involving that subject.
And what became of that tape recording? I'm referring to the 1990 tape recording, the 10-minute tape recording, after you made that tape recording.
Well, I originally started covering this story in August in 1989. And I originally was covering the story for the Miami Herald, and subsequently I wrote an article about the case for Playboy magazine, and am now writing a book about the case for Simon & Schuster. And in the course of that research over these almost 5 years, I've interviewed probably somewhere over 400 people and probably have several hundred audio cassettes of interviews and research. And my home is in Miami, Florida, although I've been spending a lot of time over here in Los Angeles. And I have many boxes of tapes back in Miami, and they are not all cataloged.
The question was, what became of that recording after you made it?
The recording was in boxes of other audio recordings that I had stored in a storage facility in Miami, Florida. And I was not aware of it at the time of the proceedings during the trial. And so since the trial, I've made an effort to go back and look through all of my original research as I continue to write the book I'm working on. And in the course of going back and looking at materials I've had in storage for several years, I discovered this tape.
At the time that you made that recording in December of 1990, were you under contract with someone?
I was under contract with Playboy magazine to write an article.
And when did that contract begin?
The contract began in October of 1990.
And what were the terms of that contract?
I'm not sure I understand your
Well, the
question.
terms of the contract, was there an agreement?
The agreement was to write an article about the Menendez case for Playboy magazine.
And did you get a written contract from Playboy?
Yes, we had a letter agreement.
Do you have a copy of that with you today?
I do not. I'm not sure if Mr. Glassman does.
Your Honor, I do not have with me a copy of the written agreement. I do have a copy, in fact, an original of the letter, or a copy that I believe was sent to Your Honor, signed by Stephen Randall of Playboy Enterprises, confirming that I believe that the agreement commenced on or about October 31 of 1989, and the article was actually published in Playboy. The date of the Playboy magazine was March of 1990. That's the off-sale date. It actually would have hit the newsstand on or about the beginning of February of 1990.
1991.
1991, I'm sorry.
Of December the 7th of 1990, from the time that you recorded that at that time, up until the time that you recently released an excerpt from that recording, have you played that recording for anyone?
Yes, I played it for a reporter.
When was that?
That would have been sometime the middle of May of 1994.
The entire tape?
No.
So what?
No, I did not play the entire tape. I played an excerpt of the tape for a reporter who was considering writing a story about some of the material from the tape.
How much of the tape did you play?
Approximately 2 minutes.
And to whom, or who is the reporter?
Your Honor, I'm going to object because I believe that that's confidential privilege, and I think that that information in and of itself should be protected by Article 1, Section 2 of the Constitution and 1070 of the Evidence Code. I don't think that we can inquire into the exact identity of anyone whom Mr. Rand has played for. I think the only thing important for Your Honor's consideration is the fact that he did play the 2-minute portion that he's indicated.
Well, let me hear the people's response to that.
Well, I think that Delaney makes it very clear that in order to properly invoke the shield law, it's necessary for the witness to establish that the information has not been disseminated,
An article was never published.
I think it's necessary for this board to determine as to whether or not the information has been disseminated, and if necessary, we may have to call another witness to determine the scope of that dissemination. It may be that this reporter too also claim some immunity or shield law in connection with that, but if there has been dissemination, that's something that he's required to establish on record.
For the record, let me just indicate that the only portion that would be at issue would be the approximate 2-minute portion that the client has indicated now that he played for another colleague, a fellow reporter. The balance of the tape would still be protected by the shield law and the state constitution.
Well, we're going beyond that. All I, at this point, asked to response concerning the question of who, the identity of the reporter. It's a very simple question. I don't think it's covered by the shield law. If he has played the tape recording for someone, they're entitled to know who it was. He played it. Who was that?
Alan Abrahamson from the Los Angeles Times.
Did he make a recording of it?
No.
Was the 10-minute recording played to any other persons, or is any portion of the 10-minute recording played to any other persons other than the persons who are identified here?
No.
Have you made copies of that 10-minute?
After receiving your subpoena, I made copies of the tape.
And do you still have all those copies in your possession?
Yes, I do.
The 2-minute excerpt that you played for Alan Abrahamson, did that include the excerpt that was recently published on Channel 2?
Yes.
And where in that 2-minute excerpt is the recently published excerpt contained?
Approximately halfway through the 2 minutes.
The recording that you played for Alan Abrahamson, was that the original recording or a copy of the recording?
It was an original.
When you say an original, you mean the original?
The original.
The excerpt that was published recently on Channel 11, or Channel 2, is that a unedited excerpt from the original recording?
I think Channel 2 edited out a remark that I made, a question in between one sentence.
Your testimony that there were actually 2 segments from the Donovan Goodreau tape that was published recently, one segment on Channel 2 and another segment on Channel 5.
The segments were the same, basically the same soundbite. Channel 5 ran a slightly longer soundbite than Channel 2. But it was the same portion of the interview.
Do you have a copy of the transcript in front of you at this time?
No, I don't.
Why
don't you give him a copy so that he'll have it if it's going to be subject to any inquiry?
Do I jump, Your Honor, or scoot up? Thank you.
Let me direct your attention to what appears to be an excerpt from a recording published on Channel 2. begins with DG, I take that refers to Donovan Goodreau.
Correct.
The transcript then reads, he told me a lot about their past and stuff, and it was similar to my past. I too was molested as a child, and I told him that, and I guess that opened the gate, and he told me, and it was like, wow, Lyle and his brother were molested. Now, those two sentences there, were they in the original recording? Are those two sentences contained together, or is there a question in between those two sentences?
After the word wow, there is a question by myself which Channel 2 chose to edit out.
What was that question?
Your Honor, I'm going to object because that has not been previously aired.
Well, we're not dealing with Channel 2 claiming any privilege. This witness published it by giving it to Channel 2, and they decided to edit it in some fashion. So clearly, you're just representing Mr. Rand, and he's published the entirety of that segment. So whether somebody else decided to edit a portion out has nothing to do with his being claim of privilege he might have.
Well, he showed it to them. They chose not to broadcast it. My position would be, if it's not been previously published to broadcast, that's the same issue that we're here concerned with.
My view is that it was broadcast and published for the purposes of the Reporter's Shield law when he gave it to, or sold it to Channel 2. In its entirety, not just the portions they elected to use. You may proceed. You order the question.
Yes, I believe it was something to the effect of, were the brothers actually molested?
Were you suggesting to him at that time that the brothers were molested?
No, I was trying to clarify his previous statement and trying to draw him out to explain his statement.
So the only material which interrupts this paragraph that we have just gone over was your single question to him: were the brothers actually molested?
Yes, that's basically, off the top of my head, that's basically it.
Will you have the tape with you today?
Yes, I do, yes.
And if necessary, you can review that tape and give us an accurate answer?
Yes.
Moving on down to the second paragraph. Once again, the initials DG appear, followed by, I'm not going to lie, but I'm not going to be the one to take the first step forward. Is that an excerpt from that tape?
Yes.
And was there material in the tape between the first paragraph that I read and the second paragraph?
Yes.
And was that material also provided to Channel 2?
Yes.
How long was the excerpt that you actually provided to Channel 2?
2 minutes.
Was the 2 minutes that you provided to Channel 2 the same excerpt as the 2-minute tape that you allowed Alan Abrahamson to listen to?
Yes.
Directing your attention now to the material which appears at the bottom of on the second half of the page that was provided to us here in court. Appears to reflect a transcript of material published on Channel 5. RR here, followed by the sentence, the one person who knows something isn't here to defend himself. Is that clear to you?
Yes.
And is this passage a passage which is also contained in the same 2-minute excerpt that you provided to Channel 2?
Yes.
There's a second paragraph beginning with the initials DG. Is that passage also a passage which is contained in the 2-minute excerpt that you provided to Channel 2.
Yes.
Did you provide Channel 2 and Channel 5 with the same 2-minute passage that you provided, or that you played for Alan Abrahamson?
Yes.
What did you mean in your declaration when you said that you licensed these particular segments?
It basically was giving permission for them to broadcast. I did want to clarify, Your Honor, that I was not paid for providing these segments.
When you did this, did you have some written agreement with the 2 television stations?
No.
You provided each with a 2-minute segment of the 10-minute tape recording?
Yes.
Did you indicate to them that there were any restrictions on their use of any portion of those 2 minutes?
I asked them to let me know what they were going to choose to broadcast.
Did that indicate that you had some veto power over what it was that they chose to use, or just that for informational purposes you wanted to know what they were going to use?
Well, for informational purposes, that they made the choice of what to broadcast. I did not instruct them on what they should broadcast.
Do they still have these tapes?
I do not know.
You did not get them back?
No, they recorded a section of the tape.
All 2 minutes or 10 minutes?
Yes. All 2 minutes.
So as far as you know, each of these stations still has the entire 2 minutes?
As far as I know. Although I don't know because I don't work at either station.
Well, you have no reason to believe they don't have them.
Correct.
And you have no reason to believe that 10 minutes after this hearing is completed, either or both of those stations will play them in their entirety? All 2 minutes?
I don't know, but they might do.
And you have no control over that one way or another?
Correct.
Did you personally make the 2-minute excerpt that you provided to Channel 2 and Channel 5?
No, I queued up the original to a point and played 2 minutes.
And allowed them to make 2 minutes from your 10-minute recording?
Yes.
You followed the same procedure in regard to both Channel 2 and Channel 5?
Yes.
The other 8 minutes of that tape, has that ever been played for anyone?
No.
And where within the 10 minutes do those 2 minutes come into play?
Approximately 6-7 minutes into the recording.
When was it that you discovered that you did in fact have a 10-minute recording of Donovan Goodreau from December 7th, 1990, in which he discussed the statement mentioned by Lyle Menendez?
It was in April 1994, this past April, that I discovered the existence of the tape.
All right, directing your attention now to the reporting that you made of the defendant, Eric Menendez. Can you tell us when it was that you made that recording?
The recording was made October 22nd, 1989.
And was the defendant aware that he was being recorded at the time?
Yes, the tape recorder was sitting on a table in front of us.
And was there any agreement or understanding concerning publication of that material?
He was aware that I was researching an article for Tropic Magazine, the Sunday magazine of the Miami Herald.
you on contract with that magazine at that time?
We didn't have a formal contract, but I had been contributing stories to the Miami Herald Sunday magazine for several years at that point. We did have an agreement that I was writing an article about the Menendez family, and I was assigned to come to California for the Miami Herald.
Are you saying that at the time that you recorded that conversation, you had been sent to California to conduct that interview by the Miami Herald?
Yes, along with other interviews and other research I was working on for the same story.
What was the terms of the contract that you had with the Miami Herald at the time?
The original story I was assigned to was to write a biography about Jose Menendez for the Sunday magazine of the Miami Herald.
And that was still the understanding that you had with the Miami Herald as of October 22nd, 1989?
Yes.
That original recording of your interview with Eric Menendez, how long was that recording?
Approximately 2.5 hours.
Do you have that recording with you today?
Yes, I do.
Now, since the time of that recording, have you published parts of that recording?
Yes.
And on how many occasions have you published parts of that recording?
I would have to refer to the notes here and count. It appears to be 9 occasions, although some of the publications were the same material as repeated on different broadcasts.
Did you ever play that recording in its entirety for anyone?
No.
And what is the total amount?
I'm sorry, actually, I did play, yes, originally, I'm sorry, I forgot. In 1990, I was working with NBC TV News on a special, and I did play the tape for them.
The entire
Yes.
2.5 hours?
Yes.
And who specifically at NBC News did you play that tape for?
A producer at NBC by the name of Holly Powell.
Sorry, Holly?
Holly Powell. P-O-W-E-L-L.
And what was your reason for playing that entire recording for her at that time?
I was working with NBC News as a consultant on a program they were producing covering the Menendez case.
And you were making that material available to her for her use?
Yes. Limited portions of it.
How are you defining when these portions were being made available to her?
Well, that only limited portions could be broadcast. I was allowing them to review the tape. However, the agreement was that only some brief segments would be played on the program.
Are you specifying those statements that could be played as you were going along, or was there an understanding prior to the time you started the tape as to the segments that they could use?
No, there was no definite terms, but we discussed different segments they were considering, and they made the decision.
They made that decision as the tape was being played for them as to what they would use, in fact?
Yes.
And you were inviting them to use all or just a portion of the tape?
Just a portion.
And did you specify as you went along which portions they could and could not use?
They told me what they would like to use, and then we had a discussion, and they chose what they broadcasted.
It was played for them prior to any understanding as to specific portions that they could use?
Yes.
Are those the portions that are in this transcript?
Yes, Your Honor.
And does this transcript on page 2 and 3 contain all of the portions that they actually used?
Are we speaking of NBC?
Yes.
Yes. Yes, it does. There are two different listings for NBC TV.
Directing your attention to the portion of the transcript appearing on page 2, which is designated hard copy, Paramount TV, March 15th, 1990. There appears to be 2 paragraphs contained in that segment with the material contained in the original recording, which comes between those 2 paragraphs, which are not reflected in this transcript.
Yes.
And what material comes between those 2 paragraphs?
Actually, these two were approximately a half hour, 45 minutes apart. I can't be sure off the top of my head.
As far as the individual sentences and individual paragraphs which appear in these excerpts contained on page 2 and 3, is there any material which is contained in the original recording which is not reflected in these individual sentences or in these individual paragraphs?
I'm not sure I understand the question. Do you mean, is there more material than is reflected on the transcript?
What I'm asking is, as we look at these individual sentences and paragraphs that appear on these 2 pages, are these sentences and paragraphs complete, that is, from them?
Let's see, they are all complete, except for on the page 3, the last graph. They did do some editing within that paragraph.
What paragraph are you referring to?
Page 3, paragraph 3 from the conspiracy tapes. They did edit out some material in the 3rd paragraph, on page 3.
And where in that paragraph was material edited out?
In between the 2 sentences, there was material edited out.
How much material was edited out in there?
Approximately 10, 15 seconds. I do not recall off the top of my head.
In between the 3 paragraphs that are reflected on page 3 of this between those paragraphs,
Yes.
directing your attention first to the transition from the 1st paragraph to the 2nd paragraph.
I believe possibly 5-10 minutes. I'm really guessing off the top of my head because I don't have the entire transcript in front of me.
Directing your attention to the transition from the 2nd paragraph to the 3rd paragraph.
Guessing, I might guess 5, 10, 15 minutes.
Going back to page 2, there appears to be designation of conspiracy tapes, 2 paragraphs which are packed close together. Is there any material that was deleted from the transition between those 2 paragraphs?
There were 3 or 4 words that were deleted, basically just things like that type of material.
Just so that I understand your procedure, when you were allowing portions of the Eric Menendez reporting to be copied, news agencies copying the passages which have been deleted from the transcript?
It was different with different programs. The only program or news organization that heard the entire tape was NBC News. The other programs, I provided sections, sound bites to them.
Did any of the news agencies record portions of the transcript, portions of the recording, which is not reflected here in the transcript of the institution?
I think there might have been a slight amount of outtakes or material, maybe a few extra seconds on either end of the soundbite that might have been recorded.
Thank you, Mr. Rand, with reference to the 2.5 hour Eric Menendez tape that you testified that you played for a producer at NBC, did they record the tape in its entirety or only the portions that were selected that were ultimately aired?
No, they only recorded the portions that were selected.
And how long were the portions that they selected and which were aired?
They selected two sound bites which were approximately, one was about 15 seconds and the other was about 10 seconds.
So the only portion of the 2.5 hour Eric Menendez tape that NBC has in their possession are the portions that were actually aired, is that correct?
Yes.
What was your intention at the time that you played the tape for Ms. Powell at NBC? Simply to allow her to listen to the tape and to select in conjunction with you only limited portions for broadcast?
Yes.
With reference to the Donovan Goodreau tape, do you have a transcript of the partial portion, that is the 2-minute portion of that tape, 2 minutes out of 10 minutes, that you played for Mr. Abrahams?
Yes.
You have that in court for review by the court if His Honor so desires?
Yes.
Your Honor, I don't believe I have anything further at this time from the client.
What arrangement, if any, did you have with Mr.
I'm not sure what you mean by arrangement, but Mr. Goodreau
Well, if you're not sure, let me ask you a different way. When you indicated that you were recording the phone call, did you indicate to him why you were recording it?
Well, we had a number of discussions that began in July of 1990, before I was assigned to work on an article for Playboy magazine. And after I began working on the Playboy article in October of 1990, we had perhaps a half dozen phone conversations, and he was aware that I was researching an article for the magazine.
That's not my question. What did you tell him as to why you were recording that particular conversation?
I told him that I was following up on some of our earlier conversations and that I was trying to plug up some holes in my story and do some follow-up questions.
And that was your explanation to him as to why you were tape recording?
Yes.
And what did he say, if anything, in regard to whether it should or should not be tape recorded?
He did not have a reaction.
Did he indicate any desire to obtain a copy of the tape recording for his own purposes?
No.
Did you offer that to him?
No.
And in regard to the Eric Menendez tape recording, Did you provide an explanation to him as to why you were tape recording?
Yes, I told him that I was researching an article for the Miami Herald.
Did he make a tape recording of that conversation himself?
Not that I was aware of.
Did he ask for a copy of the tape recording that you had made?
No.
And other than playing it, I'm referring now to the Menendez tape recording, other than playing it for an employee of NBC, you have never played that tape recording for any other human being?
I'm trying to remember if I might have played a small portion of it for my editor at the Miami Herald, but otherwise, never.
Yeah, you never played the entirety of that tape recording for another human being other than for Ms. Powell of NBC News?
Possibly an editor at the Miami Herald. I might have played a small portion. But
I'm talking about the entirety of it.
no.
You've never played the entirety for any other person?
No.
All right, anybody have anything else?
Nothing further.
Okay, you sit down. Did parties have any further evidence to offer in this matter, or requests to have access to any of the materials referred to during the testimony of Mr. Rand, or anything else other than arguing the merits of your positions?
You know, the only thing else that I wanted to include in the record would be the two letters that we had offered to the court in connection with my declaration, namely the letter from the Tropic magazine, the magazine of the Miami Herald, confirming that Mr. Rand was on assignment at the time that he interviewed Rand Menendez, and also the letter from Playboy indicating that he was on assignment for Playboy.
All right, then I'll hear argument. First, the proponent of the shield should present your position.
Your Honor, our position is, as indicated in our moving papers, namely that there is no basis whatsoever for the district attorney's office to try and turn Mr. Rand into an investigator for the people of the state of California with respect to unpublished materials. The fact that the published portions relate to the unpublished portions is immaterial and irrelevant under both Article 1, Section 2, and Evidence Code Section 1070.
Well, first of all, your position is that your client qualifies for the shield provided by Section 1070 of the Evidence Code and the similar language in the California Constitution.
Yes, Your Honor. People Bondilas, I think, makes that absolutely clear, that the fact that Mr. Rand was not a full-time employee for a wire service or a daily newspaper is irrelevant. He was on assignment. He was doing an article in each instance, either for Playboy or for the Miami Herald, and under Bondilas, that clearly qualifies. With reference to the fact...
Well, let's stop there first, because that's the threshold issue here as to whether Mr. Rand can claim the shield. All right, do you have anything further to offer with regard to that particular issue?
Bondilas is the leading authority, and I think it's clear on its face. It states that someone in circumstances virtually identical to Mr. Rand is entitled to the protection of the shield law. That's the most recent authority from the court.
All right, let me hear the people's position as to whether the shield of 1070 of the Evidence Code applies.
Yes, Your Honor. I think that there is a difference between the contracts that were involved here to the Miami Herald and the Playboy situation, and I think the court can draw a distinction between the two, and find that as to the Playboy, there appears to be more a greater contract than the Miami Herald situation.
I can't hear it.
There appears to be a distinction between the Miami Herald and the in Playboy, the court can find that while there may have been a contract as to Playboy, there was not actually a
And what is the basis for finding that there was not such a contract with the Miami Herald, or that he was not employed by the Miami Herald and were connected with, as the language of Section 1070A provides?
I think that based upon the testimony of the witness, who specified that he didn't seem to suggest that he was an ongoing series of stories. His testimony seems to suggest an indefinite contract for Playboy rather than
Your Honor, if I might just briefly respond on that issue. The portion of Von Dielis that we quoted at page 5 of our moving papers makes it absolutely clear that our position should be well taken. The court writes, the constitutional provision plainly encompasses Mr. Golab's position as a freelance writer. Golab had been a reporter or freelance writer for some 13 years prior to his involvement with the instant articles. The clear language of Article 1, Section 2B provided him with news person shield protection both before and after execution of the written Hustler contract. So the fact that there was an agreement, understanding, or contract between Mr. Rand on the one hand and Playboy and the Miami Herald, according to the Court of Appeal in Von Dielis, is not the issue. The fact is that he has been a journalist, a freelance reporter since approximately 1972. That's his life and that's his work. And I think that when he conducts interviews under Von Dielis, he is entitled to that protection.
I don't particularly agree with that broad interpretation of Von Dielis. Von Dielis was a case in which the appellate court was evaluating the record presented to the trial court and making a determination as to whether the rulings of the trial court were supported by substantial evidence in that particular case. So that is the value of Von Dielis. The teaching of the Supreme Court in Delaney versus Superior Court is that the plain language of Section 1070 is what controls. There's some ambiguity in it. And 1070 of the Evidence Code is designed to provide not a privilege, but a shield for certain purposes and certain individuals, not all individuals for all time. And the fact that somebody happens to have a certain career doesn't make that person or put that person into a different category than another person who doesn't have such a career. So that if someone is a news person or a freelance writer, that person doesn't automatically have the benefit of this shield. The purpose of the shield is that the individual who is connected with certain enterprises that would result in the publication of the material would benefit from the shield, not just anybody. Otherwise, you would have the situation of an individual who at some point in his life or her life was a freelance writer, and thereafter went to some other line of work. And the argument can be made, well, that person was at one point a freelance writer, therefore for the rest of that person's life, that person is entitled to the benefits of the shield. And that's clearly not the law.
And we don't take that position, Your Honor, nor would we take the position that's set forth as a hypothetical, and I believe, Delaney, if Mr. Rand had gone into a 7-Eleven store and while on assignment for the Menendez case or any other case, and happened to observe a burglary or a robbery in the course of happening, obviously he could be brought into court and he could be made to testify because he was there as an ordinary citizen. That's totally different. Under the circumstances of this case, both of these interviews were conducted as background source information for articles that he was then writing, either for Playboy or for the Miami Herald, the topic magazine.
That's the focus of my questions here, that these particular, or whether these particular interviews were conducted in connection with his employment, or that he was connected with or employed by a newspaper or magazine and did this work because of that connection or employment. And, I inquired of the prosecution as to how I would distinguish between the employment with the magazine and the employment with the paper, and I really don't see that there was a distinction between the two. Yeah. This court's ruling, by the way, in regard to the other tape recording, was based upon the fact that at the time that recording was made, Mr. Rand was not connected with or employed by any news organization, whether it was a newspaper, magazine, or other periodical. And that was a finding this court made based upon his testimony. But that was a different tape recording made at a different time. And now we're talking about these earlier tape recordings made at a time when Mr. Rand indicates that he was connected with a news gathering organization, whether it be a newspaper or a magazine.
There is no evidence.
The people have anything further to offer in regard to this particular issue as to whether the shield applies to Mr. Rand in regard to these two tape recordings? All right, I find that based upon the evidence presented here that the witness, Mr. Rand, is or was connected with a newspaper, magazine, or other periodical at the time he conducted these interviews, and therefore he is one who falls within the provisions of Section 1070A of the Evidence Code for the purpose of the shield. All right, so the next issue is what happens to the unpublished portions of these tape recordings, as to whether there is exception to Section 1070 as argued by the prosecution in its moving papers that would justify the court ordering that these particular tape recordings be produced. Does the prosecution intend to use the Goodreau tape recording in its case in chief?
No, I'm not anticipating that we're going to do that this time around.
All right, so why is it that you feel that you are entitled to have it at this time?
Well, because I think that there is a likelihood, just based upon the nature of the material, that it will be used, or at least the defense will attempt to use it in some way in the course of the proceedings, perhaps by using whatever excerpt they have to try to impeach Mr. Goodreau. It's our position that in order for us to properly determine whether that excerpt that has been released is in fact a reliable piece of evidence, it's necessary for us to review that matter and make our own determination as to its reliability.
And we do have defense counsel here representing both defendants. Just an inquiry as to whether or not a determination has been made by, well, let me back up. Next question of the prosecution is whether or not Mr. Goodreau would be a witness for the prosecution in its case in chief.
That's very likely at this time.
Okay, assuming Mr. Goodreau was a witness in the prosecution's case in chief, has the defense made a determination as to whether it would use this, or attempt to use anyway, the segment that has been the subject of this hearing, the Goodreau interview?
I don't think that's been decided yet, because we don't have it either.
That's correct. We have heard a portion that was published, and I assume that if Mr. Goodreau were to deny that he made those statements, we would attempt to impeach him. However, Mr. Goodreau is aware of those statements now. Perhaps his testimony would change as to whether or not he made those statements. He apparently denied it. My understanding, although I wasn't there, was that he denied making those statements in the last trial and was in fact impeached with that tape. or a portion of the other tape?
Another tape.
Another tape. Correct. If in fact you were to maintain that same position, which apparently was not true, we would attempt to impeach with both cases. However, now knowing what he said on tape, he may decide to change his testimony.
It seems that the issue the prosecution is raising is not a confrontation issue, and that's an appropriate issue, but it's related to the wrong context. If there's an expertise, I think it's not obviously burdens on the proponent of the evidence. On the proponent of the evidence, it's more complicated. I can see calling a witness like this and then to give the dates, or some other way, but I think that's not the same issue. Well, that's a different trial.
Well, another issue is if the defense elected to play a portion of the tape, there might very well be some objection by the prosecution that the portion is unreliable and should not be used out of context. And it might very well be that the tables would at that point be turned, and that the defense would be in a position of arguing that they wanted the entirety of the tape, if that would be the only way that the portion that they seek to use could be used. And it might be that at that point the defense would be seeking Mr. Rand's tape rather than the prosecution. And the reason I'm inquiring at this point on this particular tape recording is the threshold question of the need for the prosecution to obtain this tape at this point under the circumstances of the shield applying to Mr. Rand at the time he made the tape recording. Did you wish to be heard any further, Mr. Cobb?
Well, I think to address the issue of what is published and what is unpublished at this point.
Well, that's a separate issue, but I was talking about the unpublished portion at this point. Did you want to be heard further on that?
No, I do think that it is timely raised at this time because, as the court indicated, I think that it can reasonably be anticipated at this time that this tape is in fact going to be used by the defense despite their unwillingness to commit themselves at this point. If in fact Mr. Goodreau was called as a witness for the prosecution, and in light of the testimony that he gave previously in the first trial, I can't imagine a situation in which they would not try to use the published portion of the tape in some way while he is on the witness stand. So I think that it is timely raised at this time, and that we should not wait until the time of trial when who knows what has happened to the tape.
Well, that's a second issue as to how we ensure that that tape might be available if necessary, if it came to that. Yeah.
First of all, of course, Mr. Rand will preserve these tapes without the necessity of a court order. If Your Honor orders it, that's fine. We will guarantee to this court that these tapes will be preserved. But the other issue that I want to raise at this time is I don't believe that this issue is now timely. We have before the court simply a subpoena issued by the people. The Delaney Court, California Supreme Court, makes very clear that in the absence of a request by a criminal defendant, the issue has never been resolved in California.
Well, we'll get to that more appropriately in the second tape recording. We'll hear that in just a moment. My view is that it is unclear whether or not this Goodreau tape, that we've been referring to in this hearing, will be used. And if it is used, it would be used by the defense, at which time there could very well be some argument presented that the portion that the defense wants to use cannot be used unless the entirety of the tape is examined to ascertain whether or not it was taken out of context and things of that nature. This is often a situation that arises in trials where witnesses have spoken to news reporters prior to coming into court. And we saw it during the first trial, where one side or the other attempted to use statements made by a witness to a news reporter for the purpose of impeachment. And occasionally there were objections by the other side complaining that if that did occur, it would be unfair for the other side not to be permitted to examine the reporter about the entirety of the conversation, including unpublished material, to determine whether the conversation was accurately reported, to determine anything else that might have been said on the same subject, things of that nature. And more often than not, these controversies resulted in no reference being made to the interview with the media because of concerns, and it never came to a head. That is an ongoing problem, and one that we can visualize occurring in other contexts during the course of this or other trials where people have or will be interviewed by the press and then subject to testimony as to whether or not anything that they said in a published portion of an interview can be used to impeach, and then whether or not some of the unpublished material can be subject to examination so that the entirety of the witness's statement can come forward. But in the context of what's been presented here at this point, we don't know if the defense will be using this particular tape. And if we do see that occur at that point, then the issue might be different in that in order for the defense to be permitted to use that portion of the tape, they might very well have to argue that they, because of the prosecution's objections to using only a portion of the tape, that they are entitled to the entirety of the tape. And at that point, we might get to what Mr. Glassman has been ready to argue here, that the defendant has a different status in these types of disputes in regard to the reporter's shield. And that is an issue that has yet to be resolved by the Supreme Court, although it was alluded to in the Laney. So at this point, what the court will order is that the entirety of the tape recording made by Mr. Rand of his phone conversation with Mr. Goodreau be ordered preserved by Mr. Rand. And my only concern is, and it's not really my concern because I don't care if this evidence is offered or not, my only concern is if Mr. Rand for some reason was unavailable during the trial and the tape recording then became an issue as to where it would be and how it could be obtained.
I'm happy to take custody of that, Your Honor, and keep it in a lock safe in my office until such time as Your Honor finds out whether you'll have need for it and whether we have to revisit this issue.
All right, anybody have any problem with that?
So I mean, if there is a need, if there's a need for another subpoena, Mr. Glassman will accept that.
I will accept on behalf of Mr. Rand.
All right, then that will be the order that Mr. Glassman will take custody of it. Again, there is the issue of portions that were played for other people as to whether those portions have been published. And my view is that they have, that whatever was played for someone else, I'm talking now about the Goodreau tape, has been published and should be the subject of disclosure by Mr. Rand that the entirety of the tape recording has been subpoenaed. He has the entirety here. A portion of it has been published, and to that portion that has been published, he no longer has a shield that prohibits that material from being subpoenaed.
Your Honor, the court is now raising an issue that we had not previously briefed. That is, we had addressed the issue of publication through the media. We had not addressed, nor had we ever focused on, nor had the district attorney's office, the issue of just simply playing a tape to an editor at NBC, for example.
No, I'm not talking about that at this point, but we can get to that. I'll be glad to discuss that in a moment. I'm talking about the Goodreau tape at this point, which there were 2 minutes out of the 10 minutes that were played for various people. And to my view, those 2 minutes clearly have been published. Are you still going to dispute that and feel that that is in the same category as the 2.5-hour tape?
I think there's a distinction to be drawn between publication to the world in a newspaper, magazine, or on television, and publication in a much more limited sense, namely simply playing the tape to a colleague or playing it to an editor. What I would like to do is have the opportunity of a few days simply to file some additional authorities with the court on that issue.
All right, did the people wish to respond to that?
Well, Your Honor, I think that although we may not have focused on this specific issue, nevertheless, both sides did brief the cases relevant to this issue. And I think it is clear from those cases that we have already briefed that there has been a publication of the material to several different sources, Abrahamson being one of them, and then to CBS and Channel 5. So I think that there's, based upon the research that we've done already, there's an adequate basis for this court to find. But there's no question but that the material has been disclosed and should be disclosed at this time.
My position, just Your Honor, is that I think that publication has to be viewed in a larger context, and I think that the publication referred to in the Constitution and the evidence code is publication to the public. I'd like, though, to have the opportunity, even if it's just for a few days, and I gather that this case isn't going to be proceeding to trial for some months, I'd like to have the opportunity just to focus on the very limited issue of what constitutes publication. If you show it to a colleague or an editor, does that constitute publication even if it never sees the light of day? No one ever broadcasts it to the people. I think not, but I'd like the opportunity to look at the cases on that limited issue, and if I'm wrong, I will simply indicate that to the court and to Mr. Kahn, and that issue will be resolved. But I'd like a little time on that issue because no one has submitted any authorities to the court on that limited issue.
Well, also you have an additional facet here that the conversation was tape recorded. There are two things. One is the tape recording itself, and the other the content of the tape recording. The tape recording itself was played for somebody, and that person, whoever it was, heard it, listened to it, retained in his memory, or her memory, whatever it was that was on the tape recording. So that has been published, period. That's out. And now, just a question of production of the tape recording itself. I don't draw a distinction between the two, quite frankly. Once it's out, whether it's been listened to or whether the tape is actually produced.
The issue that I raised is simply...
I understand what you're saying.
The 2-minute portion's never been played to the people. It's simply been played for a given reporter who, to our knowledge, has never published it in any way.
Well, that's his decision as to what he wanted to do with it, I suppose, once he heard it. And he had discretion to publish it to the world. He chose not to, but that doesn't limit the conduct of Mr. Rand in publishing it to someone who had the capacity to publish it to the world.
Well, we don't know what Mr. Abrahamson recalls or knows, or whether he has any intention to publish whatsoever.
I don't think it matters at this point. He had the potential to do so. And if he chose not to do it, that's his decision, not Mr. Rand.
Well, again, for the record, my objection would be that I think publication in broadcast media, not simply allowing a colleague to listen to a portion of the case.
All right, what I will do is order that Mr. Rand produce the 2 minutes that was played for Mr. Abramson, and also which contains the shorter segments that he provided to the other TV stations, the 2 TV stations that have been referred to in the testimony. And I will stay that order for a period of time to give you a chance to file any further authorities that you feel that you want to. And then that order will become final if I don't modify it as a result of whatever you want to file. When would you file something?
Could we have 10 days, Your Honor?
All right. Well, how about August the 1st?
That's fine.
Monday, August the 1st. The stay will be in effect until Friday, August the 5th. That's a date when we have another hearing in this courtroom.
Friday, August 5th,
Yeah.
Your Honor?
And the August 5th hearing? Okay. Well, we'll give it until August the 5th, just in case you file something that the people want to respond to. And the people need some more time if they feel that you've raised some issues that require a response. But the stay will be until August the 5th, at which time Mr. Rand will be ordered to be in court to turn over that 2-minute segment. And if he fails to do so, he will be subject to further order of the court.
Your Honor, before the court moves on to the next aspect, we have to do this.
Well, the next aspect is still involving Mr. Glassman.
I understand, but
We need a personal emergency type recess. All right, it's 11:15. We'll take a recess and we'll resume at 10 minutes after 11. 10 minutes after 11.
I don't know.